no expectation of privacy in a public place. So consent isn't even a relevant argument. And that's pretty much the entirety of the state's position, is that they didn't consent to being searched, or sorry, didn't consent to being filmed. And therefore, their First Amendment, Mr. Reyes' First Amendment right is somehow null and void. If that was the case, anytime someone has a protest or someone has and uses any of their First Amendment rights to videotape, to protest, freedom of speech, and it bothers one individual subjectively, even though that would completely remove any First Amendment right, because one person is bothered based on fundamental protected activity. If he has a First Amendment right to film, he's in a public place filming a public official. Besides that, there's nothing that the state has argued based on his actions that could even be found. Again, if they're going to argue that he needs permission from people from the village to record, then we get into prior restraint arguments for those same constitutional rights. So based on all that, his actions, nothing he can do, nothing he's alleged to have done, based on his First Amendment protected activities and filming the public official, nothing can be deemed unreasonable. And if it's not unreasonable, then the disorderly conduct statute charge against you. Thank you.
Okay. State, you can go ahead and proceed.
This will be good.
Thank you, Your Honor. First and foremost, Your Honor, I would just like to make very clear, there is no allegation in this matter that Mr. Reyes was in any way prevented or told that he could not be present in the public location of Berwyn City Hall. Now, throughout counsel's argument, he had referenced the administrators who were present, and Your Honor, it's very clear in the police report that the complaining witness in this matter, Berwyn Green, she did sign off on the complaint. She is the city administrator. There are multiple additional witnesses who are listed throughout the police report. Upon signing the complaint, upon notifying the police who are located in the same building, Ms. Green did indicate that there were people who had brought Mr. Reyes to her attention, as well as several of the employees working in her stead who felt uncomfortable by his presence and consistent reporting. One of the follow-up arguments that was made by counsel is with regards to filming, and effectively saying that the people working at City Hall were feigning alarm when they notified the police that multiple people that were employed by the village of City Hall were made uncomfortable by his actions. Your Honor, the state referenced in our response to counsel's motion that Mr. Reyes was filming these recordings, as counsel indicated, for dissemination based on his status as a journalist. The filming that takes place within City Hall, very specifically and very intentionally, based on state requirements, is visual only. It only records what people are doing. There is no audio recording whatsoever. And the video that was taken by Mr. Reyes and eventually disseminated through his YouTube channel was both an audio as well as a visual recording. The state made reference in our response that the state of Illinois is a two-party consent state. Now, if Your Honor chooses to take a position that the secretaries as well as the administrator who represented them working at City Hall are fully considered under the public official requirement that that they can be recorded in public, that does not take into any consideration who was continuously mentioned in the state's response of the private citizens. Because it's a public building, there are private citizens located within Berwyn City Hall. There were multiple people that were on the phone with city administrators, and by Mr. Reyes being present in both audio and visually recording these people, he was recording their private conversations that were being had. And Your Honor, the requirement of that is laid out in the state's response that people do have a protected right to not have their phone conversations intercepted by a third party. Not only intercepted, Your Honor, but disseminated through his YouTube channel. And again, with Illinois being a dual-party consent state, there was no indication that people even knew that they were being recorded, let alone that their conversations were being taken down on video and put out on a YouTube channel. Your Honor, this is entirely unlawful. And based on that, he was asked really to stop reporting. He wasn't told that he couldn't file what he went in to file. He wasn't told that he couldn't either. He was merely asked to stop reporting, and he refused. Now, Your Honor, in response to Mr. Jenks' statement regarding feigning alarm, feigning alarm by the complaining witness. Your Honor, the state would ask the court to take judicial notice that upon arrest, Mr. His information was input into the lead system and an arrest card was generated. Your Honor, both the arrest card and the leads showing the defendant's any criminal history that he may or may not have indicates that he is listed as 6 foot 2 inches tall and 270 pounds. Now, Your Honor, counsel is in no position to tell someone what alarms disturbs them or provokes or disturbs their peace, particularly when someone of that stature enters into City Hall, is reporting conversations that are not only going on between employees of City Hall, anyone who's working underneath them, anyone fielding phone calls, and any of the private citizens that are present. But he also is not in a position that when they ask him to stop recording, specifically to stop audio recording those conversations between the private citizens, and he refuses, then he's not in a position to decide whether or not that alarms someone when their conversations are being recorded. Now, Your Honor, the case law that was cited by counsel, as I stated in my response, is almost entirely specific to the reporting of police officers, and we would ask that the court give it the appropriate weight based on that. And adopting all the additional argument that is included within my motion, Your Honor, we would ask that you strike down counsel's motion to dismiss, based first and foremost on the fact that he was recording and disseminating private conversations that present any of the parties, which the state position is an initial disturbance of the peace. And finally, upon being asked to stop recording those conversations, refusing to do so, therefore further disturbing the peace before it was again disseminated without consent to any of the parties.
So if I'm walking through the park and I overhear someone, I'm disorderly?
Motion, we would ask that you deny counsel's motion.
Okay, any rebuttal, counsel?
So the state continues to mention private citizens that were being reported. It's not relevant whether there's private citizens being recorded or not. This is a public space. There is no expectation of privacy in a public space. The complaining witness is not a private citizen. So arguing that a private citizen who's not even a complaining witness is somehow harmed isn't even relevant in this argument because none of them signed the complaint. They have nothing to do with this. And that the state alleging that someone that made complaints doesn't matter. Even if the alarm by the complaining witness was real, even if she actually was alarmed, it still does not take away the fact that she's a public official in a public place with no expectation of privacy, being filmed by Mr. Reyes, which he has a First Amendment right to do. Even if one individual is actually alarmed, Mr. Reyes' conduct was not unreasonable, and that's the standard under disorderly conduct. Were his actions unreasonable, objectively unreasonable, that would cause the alarm and somehow be found guilty under disorderly conduct. Doesn't matter if she was actually alarmed. If that was the standard, it's a slippery slope to remove fundamental right. The First Amendment right would be gone in any protest, any filming of anyone, simply because one subjective person is alarmed. Again, he's not alleged to have yelled, he's not alleged to have approached her in a threatening manner. The only conduct by Mr. Reyes that is alleged to have caused alarm is simply filming and being asked to stop him and saying no. Doesn't matter how loud big he is. Simply filming does not somehow impose a threat objectively on the complaining witness. The state also mentioned that Illinois is a two-party consent state. Again, she's arguing the unconstitutional law for eavesdropping. Eavesdropping has to be done surreptitiously, not out in the open. It has to do with secretly recording conversations between people.
Hold on for a minute, people, I'm hearing noise. Go ahead, Councilman.
The eavesdropping in Illinois has to do with surreptitiously recording private conversations. It cannot be assumed to be a private conversation when you're out in public. Being out in public, again, has no expectation of privacy, which anyone out having a conversation with people next to you can hear it. If it's in public, you can record it. You can see it, you can record it, you can hear it, you can record it. As long as it's not done surreptitiously in a private conversation. So the eavesdropping statute that the state continues to argue is irrelevant as well. This would be the same relative to an attorney having a conversation with a client in public. We know that privilege is they're waived, and they can't use that privilege if there's somebody nearby that can hear it because you're not in a private setting. This would go back to the same type of situation where if you're in public, there's no expectation of privacy. And that is the biggest, strongest argument in favor of this rate. Again, this is well-established law. It is a fundamental right and simply cannot just be taken away. You simply cannot take away someone's First Amendment rights to film simply because one person is alarmed. Even if that alarm is, even though if they're actually alarmed, it still doesn't matter because it has to be done on the objective unreasonableness of the person's action. And a fundamental right cannot in and of itself be deemed unreasonable. Thank you.
Okay, thank you, Counselor. Okay, as I stated before, I did read both of the motion to dismiss and the response in its entirety. And I understand defendant's counsel's arguments. The thing is, Mr. Reyes was not charged with violating the statute regarding no recording devices. He was charged with disorderly conduct, which is a very fact-driven case. I have lots of questions, but I can't ask you any of those questions, counsel, because your client has a right to remain silent. You all don't have to do anything but show up and watch. It's the state's burden when this case goes to trial, and it looks like it's definitely going to trial, to show that under the disorderly conduct statute here in Illinois, that your client committed disorderly conduct beyond a reasonable doubt. That's their burden. I have not heard any testimony from any of the witnesses, the police officers. I have no idea what they are going to say. Your client doesn't have to say anything. So because I have not heard anything,
The fuck?
and I have no idea whether or not your client committed disorderly conduct under the statute, I cannot dismiss it. The state's attorney has a right to charge whatever the state's attorney wants to charge. I have had cases before where the defendant was charged with the wrong thing. They have to show beyond a reasonable doubt under the statute that your client committed disorderly conduct. And that is a question of fact. So based on that, your motion to dismiss is going to be denied. And I think we should go ahead and set this for trial. Just so that you know, I don't do hybrid trials, meaning that the defendant is not here, okay?
He knows he'll be active.
For a trial, he knows that. Very good, just wanted to make sure of that, okay? Okay, so. Okay, so as far as a trial date, I don't know if Ms. Dunbar, if you know the officer's availability, the complaining witnesses available. Did you want to set this for one final status so that both
Shouldn't even
sides
give
can
a ruling.
determine the
Just,
availability
I'm
of the
curious.